Okay. Let's continue. Take a seat. Let's test our understanding of the first week's topics. And the question is in the meantime twofold. One, what are the problems we try to solve? And two, what are the three main pillars, as I dare to call them, of the private international law as a field of law? And those pillars are jurisdiction of judges, applicability of laws, and the recognition of foreign judges. And let's see whether we are all on one page. The row division changed a little bit, so it's not so easy to maintain the order, but that is all in the game. So don't worry about that. Let's test it. Next row on this question. Maybe we take 19 seconds to read the little fact pattern. So let's first start to get our head around the phrase late payment charge, so that there's no confusion on that. So what is your understanding of this late payment interest? Which is something that happens quite a... No, that row, yeah. Sure. But the reading was the previous 19 seconds. Neighbor?
I think when you pay later than deadline.
Yes. Then what?
Well, then you get an interest for the days you pay after the deadline.
Yeah, and you paid it to who?
To the one you owe.
Exactly. And to the creditor. So wherever there is a liability to pay a sum of money, to give money, and that liability is not fulfilled, that obligation is not performed on, then the legal systems allow the creditor to charge you a sort of extra amount that is then calculated on the basis of the principal amount in sort of percentage calculation as a sort of punishment of late payment. Why? Because the creditor is sort of playing the role of a bank. And sort of without agreeing to that, you get a loan with the creditor, and with a regular bank you have to pay interest if you get a loan. So that is sort of simulated in this type of legislation. And that happens with 99.9% of all the contracts that exist on the globe, including all the contracts you sign. So when you pay, so when you check your lease agreement from your apartment or your telephone bill or your credit card, if you pay late, then they charge you additionally. Recognize that? And then the key question is, much do you pay? And that differs from country to country. That differs from economy to economy. So if in an economy like in Spain, a commercial interest rate at a bank is, let's say, 6%. How much do you think the late payment interest in Spain is? So if parties do not make a special agreement on it, so you could put it in your contract, but normally it's not in the contract, it's in the law, in the case law. So if commercial bank charge 6% of the principal amount as interest or loan, do you think, neighbor, that the late interest rate is higher or lower than the 6% in Spain? Higher. I agree. Why? Yes. And if it would be lower, what would you do? Neighbor? So assume that the late payment interest is only 2%, and at a commercial bank it's 6%. What would you do?
I don't get it.
You wouldn't take the loan and pay later because the interest is due.
No. Would you take a loan? No.
Not from the bank.
Not from the bank, because then you have to pay more. So you actually do the other way around. You are not paying any debt, and you pay all kinds of other stuff, and that saves you 4%. So then all those creditors are your bank for just 2%. Rather than the 6% you have to pay to a bank. So then creditors would be in a disadvantaged position pertaining in relationship to the bank. And if it is higher, then it's better to get a loan and pay your creditors. And that's the incentive. So the whole idea is that there's an incentive to pay your bills. And not to allow all the companies to suffer, because companies have also bills to pay, like your salary. So if the customers are not paying the company, then you're going bankrupt. So there should be an incentive that consumers pay their bill. And that means that the late payment interest is higher than the commercial rate. And if you have to get a loan to pay your dues, then you have to go to a bank. That's then the best option. And avoid higher interest on your credit. So that is the mechanism. And we all know that the economies in the countries are different, and consequently the late payment interest rate differs from country to country. So in the Netherlands, a loan of a bank is, let's say, 2%. So late payment interest is sort of 3%. Then you have this sort of incentive. But in Spain, it's, I believe, 8%. So late payment interest is sort of 9%. So then you have differences like 5 or 8 are easily within these various economies already in the European Union. So let's apply the sort of questions and reasoning we tried before the break to this dispute. Which parties prefer which law? Neighbor.
Well, the creditors prefer the 5%.
Yes.
And debtors prefer the 8%.
Is that correct, neighbor?
No.
Oh, it's the other way.
Yeah.
Yeah.
So the creditor, so the one who is entitled to the money prefers the higher. Okay. So now state B is Belgium and state A is Austria. And you have a Belgium and Austrian party. could you construe your case that you, as a plaintiff, so before we end there, who's the plaintiff in these types of cases? Why?
Because he wants the money.
As simple as that. And so, each time again, do the role play. Who are you? And as a debtor, are you eager to go to court? No. You know, no one sends you an email or calls you. Maybe you get away with it. So there's no incentive for a debtor to go to court. So it's the debtor who is the plaintiff. So how do we get the plaintiff in Belgium? So now we move from applicable law to jurisdiction. Because applicable law is sort of in the air, you know? You need a judge to actually do the trick of adjudication. These two topics always go hand in hand. It's not interesting to discuss applicable law if you're not having a sort of clue in which court you end up, because there's no relevance to study Chinese law if there's no judge in the nearby surrounding that will apply Chinese law. So then you have maybe a academic interest in Chinese law, but not in practical sense in the Netherlands or Belgium or Austria, if there's no chance that it will be used. And so that's the link. How do we get the creditor in Austria? Based on the sort of emotions of before the break. Which question do we then basically answer?
State A is Austria, correct?
Yeah. Then B is Belgium. So we start at the first row. So what was the sort of critical thing to open the doors of the court in Austria in this situation? Who's ultimately deciding that, the admissibility? One by one. The defendant? Yeah. Okay, so how many people are in the courtroom?
Defendant, the judge.
So three?
Three, basically.
Basically, so three critical persons.
Yes.
So three options of who decides. The defendant, the plaintiff, or the judge. Who decides on the admissibility of the case? The judge. Exactly. Why? He's the authority. He's the boss. No, it's his courtroom. It's not sort of the courtroom of the plaintiff or the defendant, you know. So it's, and who is giving instructions to the judge? Yeah, but let's say when you look at the job description of the judge, who's paying the judge? The state. So the state, so who decides what the judge is doing? The state. And within the state, who is doing that? Legislator, and what sort of the legal instrument that dictates? And then, of course, in litigation, what type of legal instruments did you mean? Civil code, the civil procedural codes. So the rule on the judges. So the civil procedural codes, including the rules on admissibility, the job description of the judge. And so it's the same question as before the break. Does the Austrian legal society allow the judge to hear the case, yes or no? That question do we ask. But we are on the front row. So if the judge decides, how could we, so when would the judge in Austria decide to hear this case? So this is the upside down situation.
I can't get the question.
So it's about Austria.
Yeah.
It's about the Austrian judge. And the question is, when would this Austrian judge accept the case?
Because that's laws relating to the case.
Yeah, so there's late payment interest rules in Austria, 8%. No?
The parties consent.
Option 1, that the parties consent. And that Austrian rule says, judge, if both parties are eager to litigate and they pay the dues,
But that
then
depends.
be made.
But that depends on the on the legislation. in the
Yes.
state.
So we do talk about the legislation of Austria.
Yeah, but then it isn't necessarily the plaintiff and the defendant that decide on
No.
that.
So we are not completely there.
Oh,
But it could be that in Austria, voluntary jurisdiction is accepted. But if, let's say, a Saudi and an Iraqi plaintiff and defendant are appearing in a court in Austria, and they say, we love you, judge, we want to stay here. And now you're the same Austrian taxpayer. Do you want to spend your tax money on those cases? Depends. Yeah, but in general, why would you? Please go to your own country.
even there is an interest for Austria to use the case.
Sure. So if it is about a child that is living there, so there could be. But if these are the facts, so initially you need more information to say yes. Where the opposite, if it is an Austrian plaintiff, an Austrian defendant, and an Austrian judge, initially you say yes. Because where else could he go? You know, what's the whole point of a court system if you do not accept your own citizen? So there are two opposite initial reactions. Let's make it a little bit more precise. So we know that the plaintiff starts the case. So what should be the characteristic of the plaintiff to get an initial yes from the Austrian judge?
National Austria, if the judge knows that the money that's going to come is going to circulate in the Austrian economy.
And so a reason could be that if the plaintiff is Austrian, the Austrians allow plaintiffs to sue for Austrian judges, then he could say yes. But the interest rate is lower in Austria. So what could be an alternative reason? What could be the characteristic of the defendant to have a full swing yes of the Austrian judge in terms of admissibility, jurisdiction? We move to the next.
It's a low rate for him.
Yes? But now on the admissibility. So the judge's perspective? Yes? Yeah, so what should be the characteristic now of the defendant? So this was the plaintiff, now we move to the defendant. Ladies? The defendant. What characteristic should the defendant have to easily seduce the judge to accept jurisdiction? Neighbor? Come to you. Much less. Okay, so if the defendant already agreed, could be an option. But if there's no such agreement, what other characteristic of the defendant could trigger a yes from the Austrian judge? And remember what we felt before the break. Yes?
Maybe if he knows that the person has enough cholesterol to pay the debt.
Yeah? So the debtor is a millionaire. what characteristic makes the judge in Austria say, Willkommen?
He can appear in court.
He can appear, so he can agree. He can voluntarily appear. We had that. What else? Without having to do anything.
He understands the language.
He understands the language, which is then a hint on. So, with which nationality would the Austrian judge be immediately happy to accept jurisdiction? That's the Austrian nationality. Because the whole reasoning is that if then the defendant loses, then the Austrian judgment can be executed on the Austrian national, on the Austrian assets, you know, those chalets in the mountains, under Austrian law. And so there we agreed before the break, but we forgot, that that is one of the scenarios where we feel most comfortable in saying, we accept jurisdiction because then the Austrian judge can make sure that the Austrian national gets a proper defense. So there is sort of additional protection possible. You can even favor your co-national defendant. And so those are all emotions on green. A defendant and the judge that is living around the corner of the defendant. So if, as a plaintiff, you want to be sure that a judge will listen to you, and that your assets that the assets of the defendant can be attached and executed, then you have to go to the place of the defendant. That's the safest. Even to the extent that you give away a few percent. Because in Belgium, it's the mirror situation. We have the same problems as we encounter each time. But there's a plaintiff, but no defendant of the state. What sense does it make to execute those, to admit these type of cases? So what I invite you to do is, on the basis of these drawings, ask yourself each time, who is who? So from two perspectives, from the party's perspective, nationality-wise, or from the judge's perspective. Which judge likes to adjudicate the case? And that liking is based on his talk with the boss, who decides whether he did a good job or not a good job. And so the state, who is paying the salary. And that is basically the driver of the judge. So the legislation in the bank of the judge is made by the same people who pay the salary of the judge. And they decide, that phenomena decides whether a judge is inclined to say a logical yes to admissibility or not. Question?
How many cases are like that? I mean, there is a general terms and conditions that you state your jurisdiction in your general terms and conditions. Most likely. To prevent such.
Yeah, but the question is, are those terms and conditions always valid? And there are multiple options, apart from the general terms and conditions, to have jurisdiction in another state. And we will meet those alternatives. So on a daily basis, in all the member states of the European Union, judges are, let's say, so there are 10 courts in the Netherlands, and in each court, 10 times a day, a judge is asking these questions. Whether